Hi, everyone. My name is Tom Ferrasi, and I'm the Planning and Economic Development Manager with the Village of Carol Stream. I'm also the Planning Officials Development Officer for our state planning chapter, and I want to welcome you to our webinar on taking the mystery out of findings of fact. This is our Commissioner's Edition on this topic, and we recently hosted a Planner's Edition webinar on the same topic as well. So to give you a little bit of background on how this webinar came to fruition, hopefully everyone is aware that the state planning chapter offers commissioner training where we go out to communities and provide training to planning commissioners and zoning board members. Hopefully some of you have actually participated in those training sessions in your very own community. During these training sessions, we review such topics as commissioners' roles and responsibilities, how to deal with potential conflict of interest, and how to effectively utilize findings of fact. Excuse me. We decided to take a deeper dive into some of the topics discussed during our training sessions. And based on feedback from sessions, the first topic that won the prize for that deeper dive is our topic today, which is findings of fact. So our speakers, Phil and Aaron, who I'll let them introduce themselves, are going to guide you through this webinar, and I'm going to turn things over to them now. I also just want to mention that we'll have a poll question, so make sure you're able to utilize the poll feature here in Zoom. And we're going to be using the chat option versus having folks utilizing their microphone. So just keep that in mind as well. So if you have a question or a comment, please type it into the chat. So without further ado, I will pass it over to Aaron and Phil.
Okay. Hi, everyone. I'm so glad you're here with us today. Thank you for joining us on a very cold, somewhat late Thursday night in February to talk about findings of fact. To introduce myself briefly, I'm an attorney at Ansel Glink. I work out of our Chicago office, but we have offices in Crystal Lake, Vernon Hills, Naperville, Oak Lawn, Bloomington. We're all over the state. We represent just over 250 units of local government, and I'm one of the members of our zoning and land use group. So I frequently work with communities to evaluate applications for zoning relief, work on redevelopment agreements, and do all that fun stuff with staff on a daily basis, and as well as advising plan commissions when the need arises. So again, thanks for being here tonight, and I'm really excited to be with all of you.
Hi, everybody. My name is Phil Green. I am the Transportation and Long Range Planner with the Village of Hoffman Estates. And I'm also the elected at-large officer of APA Illinois, and I'm one of the Plan Commission trainers with APA Illinois, have been for a few years at this point. Had the pleasure of traveling to a dozen or so different communities throughout the state. And like Tom said, this comes up a lot, right? We have a lot of different things that we talk about when we meet these different plan commissioners, and findings of fact or standards is one of our topics that comes up over and over again that people want that deeper dive into. I know we have a couple of Hoffman Estates Plan and Zoning Commissioners on tonight's call, and they will be the first to tell you that I have a lot of opinions on standards and findings of fact. So very, very excited to be with you here tonight. I'm not an attorney, but I have played one on stage, so I think that's good enough.
You do have a striking resemblance to Mr. Atticus Finch, so absolutely. So I would be remiss as an attorney not to give a quick disclaimer before we start our session. So, we want to acknowledge from the top that no one knows your community, the community you serve in your capacity as a commissioner, better than you do, and or better than the professional staff you work with. So throughout the presentation, we'll have some sample code language. We'll have standards for everyone to review, and we'll have kind of scenarios we're going to go through. But we want to recognize that different communities do things a little differently at commission hearings. I am an attorney, certainly, but for legal advice, you should always contact your community's local counsel. Staff can put put your questions through to them, and they're happy to work through any issues you might have related to standards. And then generally, this presentation has our general advice and our thoughts on best practices for evaluating standards and findings of fact. But we recognize that zoning codes differ. Whether or not your community is home rule can affect how the findings impact you in litigation down the road. Knock on wood, that never happens. And then, of course, the community-specific standards, who your staff is, the political situation in your community, what kind of development is being considered, what kind of, the on the balance, where your zoning districts are. Those are all complicating factors. So to the extent you have specific questions, again, direct them to your professional staff and they can work with your attorney to get those sorted out. But for tonight, we're gonna proceed and talk through the findings of fact on a general advisory level.
Cool. So to that, and we know that a lot of communities do things slightly differently. So Tom's going to launch a poll question. And we're interested to know in your community where you are a commissioner, who is drafting the findings that you're seeing? We know some communities have the staff do it. Some communities will have the applicant do it. Some communities will have the commissioners themselves kind of draft those findings in real time. So we're going to leave that open. It should have just popped up on your screens there. We'll leave it open for a little minute. But we're really here tonight to kind of help you through some of not only the drafting and how to interpret that, but also how you use them. And really, when we speak to different commissioners, a lot of the time the standards can feel constricting, right? And a lot of the complaints I hear when I go to different commissioners is that they feel like they're kind of hemmed in, and I'm not here to tell you that you're not. I'm here to tell you that you are, right? And that they are a guideline and a guardrail that is there to help you, right? Your role as a commissioner, and again, this is something that we go through a lot, you are a public hearing body. You are there to help roll out the policies as decided by your elected officials. You're not a policy making body, you're a policy enforcing body almost, right? And so these standards are really there to help you, not only when we're going to talk a little bit about what litigation might look like, but they're also, I like to think of them as a common language between an applicant, a commission, and the members of the public. They help us with that transparency. All right, cool. We can close that poll. It looks like for the vast majority of folks, your staff is drafting your findings. I'm a big fan of that. Personally speaking, that's one of our jobs as professional planners is we think about all the different data points, the plan sets you'll see, the applicant's point of view, public testimony, and it's never an opinion or a recommendation of staff. It's more our work to analyze and synthesize all of that data. Some communities will have applicants do it. Sometimes that can get difficult because an applicant is always going to say, yes, I meet all of these standards. And it's not always necessarily the most technical of documents that you're going to see from them. I like to see both. I like you to see how the applicant is responding to them, but also have staff's view on that too. So let's dive in. A little refresher on what findings of fact are, and then Erin will take us a little bit deeper. But I like to think of them in terms of an even playing field, right? And I think the absolute worst case scenario for any community ever is to have one of their decisions flagged as, we'll use the legal lingo of arbitrary and capricious, or in a scarier term, perhaps, discriminatory, right? The whole point of our standards is to make sure that when we're making our recommendations that they are set to a certain standard. And we use the term findings of fact in this webinar. We'll go into that a little bit more, but I always like to have my commissioners thinking more in terms of the word standards than findings of fact, because fact has a very normal use in our real life. Here, it's a very specific, a very technical term. So I think the first hurdle to get over is to just think of your findings of fact as just the name of a document, right? At its most basic. That's just what we're calling this document. What is on the document are the standards that are set forth in your zoning code. And then it is a summation or an average of the commissioner's response to those standards as to how they feel a case has met those standards or not, right? And we'll go a little bit more in depth on that as we move forward.
Yeah, so here's a very somewhat boiled down version of the typical hearing procedure for Plan Commission, ZBA hearing, whatever body you're part of. And really what I want to highlight here is that throughout the process, from point A to point Z, you're focusing on the findings. So, as I said, your community might do things a little differently, but throughout the presentation by the applicant, the testimony from the applicant, members of the public, and then the commission's consideration process, your deliberations, findings should be at the forefront of your mind. And as Phil said, that's because the findings bridge the gap between what the applicant has submitted and the zoning code. And it creates a common language. I really like that analogy Phil uses, because it just means that everyone's on the same page from start to finish. So when the applicant's submitting their application, they have to review the findings. Most zoning applications have the findings listed, the standards listed, to say, if it's going to prompt the applicant to submit findings, they have to, explain why they've met the standards. Then when staff are reviewing them, the findings are certainly at the forefront of their mind. And then by the time it gets to you on the commission, the standards are really the guidelines for how you make your decision. And, we want to encourage, as you're being presented with testimony, the presentation from the applicant, if you review your packets ahead of time, which we always recommend. I know sometimes your meetings are late at night and you've been working all day, and reviewing the packet is an onerous task. But really what it can help you do is start getting in that mindset, that framework of, oh, what are the findings? They're usually provided in your packet one way or another, so you can orient yourself to the application before you get started. And then as the testimony is rolling in, you can ask really critical questions like, what testimony has been presented to establish the findings? Is the testimony or evidence credible? How much weight should be given to it? Does it lean towards one finding or another? And then ultimately, and this is kind of a different conversation. Maybe this is Plan Commission training 301 instead of 201. But, what kind of conditions might be considered to be applied or required of the applicant to help them get to the finish line, to help them meet the standards in a way that's consistent with your community's code and other considerations. So again, it's sort of like the through line through the process, the little orange arrows on the chart. I like to think that the findings are that through line, because it's the guiding principles for your consideration and the conversations you're having during the hearing and your deliberations. So briefly, I want to talk a little bit about final decisions versus recommendations. So on the slide here, generally speaking, we like to break down zoning decisions into two types. And this has to do a little bit with a case that was passed in the early 2000s or decided in the early 2000s, and a subsequent legislative amendment that was passed by the General Assembly in 2006, I believe, that addressed the role of, what are zoning decisions? Are they legislative decisions? Are they administrative decisions? And what does that mean for a community who's faced with, tens or in some, tens of zoning applications every year? So on the one hand, we have legislative decisions, which are the broader policy-based decisions, plan amendments, text amendments, map amendments, that typically the way you can identify them is how many pieces of property does this impact? A text amendment, if it's impacting, the permitted uses in the commercial district in your community, then that's going to impact the entire zoning district. And that's that's probably many different parcels. On the other hand, there are more individual decisions that are made, special use permits, variations, subdivision maps for new developments that have a somewhat narrower lens. And in the vein of these two types of decisions, the other thing we like to think about a lot, and I want to remind everyone of, is that typically the Plan Commission is the recommending body. So in most cases, when you're considering an application, you're recommending approval or recommending denial. That's probably very familiar to all of you when you're, raising the motion to approve or deny. In some cases, however, the Plan Commission in certain communities does make final decisions. I work with a couple communities where certain site plan review processes are through final decision making at the Plan Commission level. And then also certain minimal variations, setbacks that are less than 10%, a less than 10% increase in the setback, for example, or decrease in the setback would be made as a final decision by the Plan Commission. And that distinction is really important because as a recommending body, if litigation were to ensue, the recommendation body isn't, their decision is not challenged typically. It's the legislative decision of the city council or the village board that's challenged. And there's a really deferential standard there. It's a rational basis standard, which means the court is kind of looking to see, is there any reason, any rational basis that this application was approved or denied by the village board or city council? And that's a great scenario for attorneys and local governments alike. When the Plan Commission makes a final decision, however, the standard is a little different. It goes up on administrative review instead. And what that means is that the court is going to take the record that was produced at the Plan Commission, so the minutes, any documents that were submitted to the commission, all of the items that were before the commission in the first round of review, and see whether or not there is a rational basis based on what they have in front of them. They're not going to look to external aids or any other materials. So in that scenario where the Plan Commission is the final decision maker, the findings are absolutely critical because the judge is going to be looking to see if those were established, to make sure that the decision was rational and that whatever is being challenged, is it a valid challenge to the decision? So that colors the context for this a little bit more too. Think about in your community whether or not you ever make final decisions, and make sure that your findings, they're always important, but in those scenarios, they are absolutely critical to moving forward through the zoning process with as few, bumps as possible. Okay, so a little more background on why they're so important. We talked a little bit about like the analytical importance of findings, and Phil and I's philosophical feelings about findings, about why they're so important and how they can bind, the public, you guys as plan commissioners, the applicant, to all understand what we're doing at a hearing and what the standards are for considering an application. But practically speaking, findings are also required by statute. So under the municipal code, a variation or a special use permit, there's a requirement that findings are established. And as recently, that's an old case, that's 1968, but again, time and again, the findings are relied upon by courts to say, the findings are not only, the guiding principle for making decisions, but they're the evidence that a rational basis was there. So, the Supreme Court has upheld that as well. And so being required by statute is certainly an important reason to pay attention and apply the findings as rigorously as you can.
This goes into a little bit more of that philosophy, and we've already talked a little bit about, that idea of them as a shared language, right? They really help with that transparency between the applicant, between the commissioner, between staff, and between the public. I think the other thing where they're really useful, to speak candidly to a virtual room full of commissioners, you've probably all experienced some pretty tense public hearings, right? There's a lot of emotion that can run pretty high at these things. There's a lot of interesting academic literature. I say interesting, knowing full well that it's probably interesting to an audience of one, and that one is me. But there is a lot of interesting academic literature about the role the public plays in the process, right? And it's a very important role. And all of you as commissioners are often there as kind of the ultimate voice of that community, right? And it all filters through you to be passed on to the ultimate decision makers. Sometimes that puts you in a very difficult position. Sometimes you're in a public hearing that can get very, very tense, very fraught, and there's a lot of information being thrown at you. And that's why I don't love the term findings of fact, because a question I get a lot from commissioners is, well, how do I know what a fact is? A lot of things are being said. Are they all facts? And really, that's why I like you to think of it as just the title of a document, because it is your finding about whether or not these standards have been met. And that can be a very, very useful barrier for you, especially my chair people who are in the room tonight. You will get a lot of people often getting very upset about things that are completely outside of your purview. A lot of the times it gets very, very difficult, where you'll have people saying some things about, you see this a lot like group homes and residential communities, and you'll hear the term those people, and that's very, very uncomfortable, dangerous, and shaky ground for all of us involved. And for my chair people in the room, the findings and the standards can be very, very helpful for you to look at them and say, hey, I thank you for your comment, completely appreciate your point of view. This body is only concerned with these particular standards. That is a very, very helpful thing for you to have. Not only in terms of making it very clear, if there ever is litigation, that your decision was not prejudiced, but also in making it very clear to the public that there are certain things that are just completely and utterly outside of your jurisdiction. Also see a comment about the Sister Cities Association. So cool. It's a very nice building.
Yeah, so we've been dancing around the topic of litigation a little bit. And the thing about the findings is we actually had a planner before the last session ask, why do findings are helpful, they're a guiding line, but do they ever come up in litigation? And really, at the end of the day, the findings they map very closely onto the standards courts use when evaluating typical zoning challenges. So, Paula, actually, you can skip to the next slide, please. I think this will be helpful, although there's a lot of text on it, so you don't have to memorize it. There's no quiz at the end. But the typical zoning challenge that communities face is a substantive due process challenge, which says, there was no rational basis for this decision. It's usually the applicant saying my application was wrongfully denied, or a neighbor saying, no, that application was wrongfully approved. This is going to, ruin my property value, and it's not good for the neighborhood. And the way that courts organize their assessment of whether or not the decision was rational, as I hinted to earlier, is maps largely onto the findings, and that's not by accident. So there are a couple analyses that the court uses. There are 8 or 9 factors that they look at to say, is this rational on the balance of things? Was the decision fair and rational? And largely speaking, the standards, the findings of fact that are implemented in your local code mirror those factors that a court would use. So yes, it's important in part because it plays this great role in priming, in case there is litigation, to say, oh, we understand what the court would be looking for. And here there are examples of zoning cases that go up to the appellate court, that go up to the Supreme Court in Illinois. So typically speaking, the typical remedy is that where no findings were adopted, they'll send it back to the Plan Commission for adoption of findings. In more complicated cases, they'll go through that very expensive process of filing a complaint, going through discovery, having motion practice, and then ultimately, and we have had a couple cases that have gone to trial on these very same issues that we're talking about tonight. So kind of our best case scenario is the court remands it to the ZBA or the BCC, and you're back at the table at square one, which is frustrating for everyone. And then the worst case scenario is that the failure to adopt standards or to make a rational decision at both levels, could result in a finding that the decision was arbitrary. And that litigation is incredibly complicated, because then the court is undertaking the analysis you all have to undertake in your very difficult role and say, was it a good use of the property? Did it negatively impact the neighboring properties? And the expert witnesses, the depositions that have to be taken, it's by no means a painless process.
I say it the way that the attorneys can't say it, which is that the absolute worst case scenario is that the thing that you didn't want to get approved is now not only approved, but you're paying for it to get built. Cool. So you guys see a lot of cases, right? A lot of different types of cases. Again, this is sample code language. It's very good sample code language. So if you don't like the code language you currently have, you'll get a copy of these slides. Talk to your staff. So let's look at some sample standards for variations. All right.
So like I said, no quiz at the end, and there's a lot of text on the slide, so you don't have to memorize it. But I want to just highlight very quickly for each of these, what the standards are based on and what we're really, if you don't like looking at the bullet point list, maybe it's helpful to give just a summary of what the relief is that's being sought and kind of what's unique about it. So a variation, is a unique form of relief that's tied to the land typically. It's, I need a variation on the setback standard because my property is so uniquely shaped or located that the setback standard takes away the valuable use of my property. I can't use it for any valuable purpose. And so that's why variations, the first thing that you look at is, the conditions that are unique to the subject property. What is different about the property owner's property that makes a variation, desirable from their perspective? And then the other issue I want to point out is sub item D. So, when you're thinking about a variation, typically part of the assessment is this the minimum variation necessary to alleviate that hardship that's created by the conditions on the property? So kind of taking a measured, conservative lowercase c approach to variations is usually what's encouraged by the standards and the zoning code.
Yeah, a couple things from me on that one. You'll notice in this example language, it says affirmative finding. Variations usually held to a little bit of a higher standard. Some communities don't require it to be an affirmative finding. My community right now, it is not written that way. It will be written that way in the future. Variations are hard, and we hear this a lot from planning commissioners when we're out and about and training because it's often residential. And so usually when you have your big commercial properties, they have planners and they have landscape architects and they have attorneys on a team who are well versed in this, right? A lot of the time your variation is a neighbor. It's someone doing this by themselves because they want a little bit of a bigger garage and they're not as well versed in this. So that's where having these standards can be so helpful for you and sticking to them, because a neighbor is going to bring some very emotional evidence to the table 9 times out of 10. It's going to be about the child who they want them to play and they need a bigger fence for that for some reason. It's going to be about the car that they just purchased that doesn't fit in the garage, and you're going to feel very bad for them. But if you don't think that variation makes sense because there's nothing unique about the property, use these standards and refer to them and have that put some distance between you and the emotion that that applicant is going to bring to this case. Let's talk about special uses.
Yeah. Do you want to talk about it, Phil? I can as well. A special use. I'll just say that a special use for, I know you guys are all familiar, and I would guess that this is a significant portion of the applications you see are special use permit applications. So, a special use permit is, under the zoning code, there are permitted uses. There's, uses that are permitted with a special use permit. So it's a use that's allowed so long as it doesn't negatively impact nearby properties. And the standards that we have here are designed to measure, whether a use would have a negative property or a negative effect on those surrounding properties. So you'll notice that these standards are pretty granular and specific. Is it injurious to the enjoyment and use of neighbors? Thank you, Kevin, for noting that in the comments. In some communities, they're not called special uses, though they're called conditional uses. What are the utilities like? Will it improve the orderly development of your community? And rather than, we talked about a variation running with the land. A special use permit typically does not. If someone moves, the special use doesn't stay on the property. So that's something to consider as well. And I don't know, Phil, if you had anything to add. I sort of jumped in.
Yeah, no, I mean, we hear a lot when we're talking to commissioners about, sometimes special uses feel a little bit pointless to them. They feel like, well, why am I even thinking about this? We're probably going to approve it. Talk to your staff at that point, because if these special uses are continually getting approved, chances are that means your code is outdated and needs to be updated, right? Erin, a question that I get a lot, and I'm interested in your thoughts on from commissioners is, okay, let's say I'm going to use a bad example on purpose here, but let's say sandwich shops are a special use in town, right? And let's say last month we approved a Subway to open up in town. And this month, Jimmy John's wants to open up next door. Should we say no to that because we're worried about competition between sandwich shops?
That's interesting. I thought you were going to ask, should we approve it because we approved Subway's
Both
application
questions
last
are on
month?
the
Yeah.
table. I think they both have the same answer at
They
the
have
end
the
of the day,
same
right?
answer, and that is that each permit application should be reviewed separately under the standards with the criteria under the zoning code. And I know that that can seem unfair, and actually we've had testimony from, other competitor business owners saying this, this doesn't make any sense. I'm right down the block. This is going to run me out of business. That is not, one of the standards. Obviously, it says that it's not a nuisance or it's not injurious to the surrounding development and property. But when it comes to those applications, they should be considered unique to one another. And I would advise that, considerations of competitive business don't fall within the ambit of, orderly development from a land use perspective.
Let's see some text amendments.
Oh yeah, text amendments. So text amendments, if you guys remember that slide that was just a few minutes ago with the green and the red text amendments are, one of those items that has a huge impact, because it will impact, it can impact a whole zoning district. It could impact, whether a use is a special, required to go through the special use permit process, or now it's a permitted use, so it doesn't have to. And the one thing that I want to point out here in particular is that item C. So we all kind of know that, as Phil said, if a special use is more and more being approved routinely because it just makes sense, maybe a text amendment is necessary to make it a permitted use instead of a special use or a conditional use. But I think item C is really interesting to think about. So is the amendment necessary because of changes in your community or changes in planning concepts or the comprehensive plan and priorities? And so, that's a really hard question to answer, I think, in your role as a commissioner. I'm sure you're all in tune with the development in your area, and that's why you're doing the service you're doing to in your communities. But it's really thinking about that too, and making sure that, again, in some ways, that's a kind of lowercase c conservative standard, right? Because we want to make sure it's necessary. We want to make sure that the zoning code actually reflects what's going on in the community and the community's planning and land use priorities. And so I think the text amendment review criteria are interesting because you get to kind of wear a more legislative hat typically in assessing the standards.
This is one of those really interesting ones for a professional planner too. Not to sound like I'm going through therapy with this, but a lot of the times our job is difficult because um, everyone lives in a community, and so everyone feels like they're an expert in living in a community. And why is a planner more of an expert than me because I live in a place? And I don't mean like in that specific community, but I mean in general, right? The thing that we do professionally is we're just professionals at living, right? That's what we do. And it seems on its surface very, very common sense, right? But this is where you can really turn to your staff. And if an applicant is presenting you the next big thing, it's a reasonable question to ask of your staff. Staff, is this the next big thing? And what you'll get back from your staff is not an opinion based on, yeah, this sounds kind of cool. I think it'll be great for the community. What you'll get is our academic study of the market, of trends in other communities. We will have done the work on this case to be able to provide you the best information we can about the suitability, especially in these new and emerging market uses.
Absolutely.
Cool. Rezonings.
Map amendments. So as you know, text amendments versus map amendments, they're what they sound like. So a text amendment amends the text of the zoning code and the regulations. A map amendment changes traditionally the zoning designation for a specific parcel of property. So, when we're thinking about map amendments, some of the things we want to talk about is, and I think criteria F, how long has the property been vacant as it's zoned? Is it still, is it useful to have it zoned the way it is if it hasn't been developed or it's vacant or not being used? What is the suitability of the subject property? What are neighboring properties zoned as? If you've got one kind of remaining bit of industrially zoned property in a pool of commercially zoned property, maybe it's time to, if someone comes in with an application for a map amendment, those are all fair considerations. And then of course the community need, again, that kind of is what we were talking about with text amendments a little bit. It's a good idea to talk to staff, and they might turn to attorneys as well, because oftentimes communities have gone through the same process, the same questions. So recently I was working on an ordinance about EV infrastructure, electric vehicle infrastructure, a text amendment. And one of the first things we like to do is, obviously there are statutes now that govern electric vehicle charging, but there are also communities who, some of our larger home rule communities, have really taken a stab at being kind of the guinea pigs for some of these regulations. And it's good to look at what's worked and what hasn't worked. And I think that's a really valuable insight, even recognizing that different communities are different. But it's a good baseline to get started. And map amendments are, again, sort of an interesting, unique process for all of you.
I think that's a really key thing, right? Like these should not be documents that don't change. These should be living documents. There should be text amendments coming before you somewhat frequently, because things change and we try things, they don't work, someone else does something new, market conditions change over time. So we should be seeing text amendments and map amendments, I wouldn't say often, but with some regularity. Things should be changing. We've had a lot of questions on these things specifically. Erin, I don't know, do we want to pause and take questions on this while it's all open, or do we want to plow ahead?
I think if we go through some of the scenarios, Phil, we might be able
We might
to
answer some of them.
implicitly answer some questions, and then we will, of course, get to what we can by the end. I just think the scenarios might be helpful.
Cool. All right. So to that end, we're going to be looking to you folks to use the chat to respond to some of this, and we'll kind of talk through our thoughts and some what we think is best practice by giving you some scenarios. These are all sanitized, real things that we've experienced ourselves or we've had relayed to us from some of the communities that we have worked with in training. So all of this is distinctly possible, is what I will say. So let's go with the first one. So the case before you is a special use for a car wash. These are often special uses. Again, we should consider that this is a permitted use by the code. What we're examining here is we're using those standards to see, okay, are there impacts that we need to consider? During your hearing, a homeowner is providing testimony against that car wash. You're in a pretty small room for this hearing, and the homeowner has brought a vacuum cleaner and they've put it on full volume to really bring home the point for you that this will be loud in their home. The draft findings before you state that the use will not impede light or air. One of the commissioners that you're with asks, does this counteract that? And we want to know, what do you think? Does that evidence counteract the finding that it will impede light and air? Again, feel free to respond in the chat. We can talk through our thoughts.
Right. Well, I'm not seeing a ton of action in the chat, so Phil, you and I can get started, I guess. So I think one thing I hoped to mention on the slide that had the chart on it, that long chart of the hearing process. But, one of the things that when it comes to the introduction of evidence or testimony, and we can categorize, what the homeowners brought in, the vacuum cleaner, as a form of testimony. They're testifying that it's going to make too much noise. In addition to thinking about the relevance of the evidence, which is the main question, does the sound have anything to do with light and air? We also can think about the weight the evidence has. Those are kind of the two. That's kind of a lawyerly way to think about evidence, but it's helpful, right? It's, is it relevant? And then how much weight do we give it if it is relevant? So if you're dubious about, you know, the vacuum cleaner, you know, if you're dubious that that's a fair representation of the sound, maybe you don't give it as much weight, you know. But we had a question in the chat, you know, where did the findings state that use would not impede air come from? I don't know if you want to go back.
Yep, should be on the screen now.
So I think that generally falls under finding C. Would you say that, Phil, that it, you know, it doesn't
Yeah,
impede the use and enjoyment of neighboring properties because there's no
right.
impediment to light or air?
So some codes are very specific about light and air. Other codes are a little bit more general, like this one, injurious to the use and enjoyment of other property. There's a lot of good discussion in the chat about what is adequate light and air. And the correct answer to that is your role as a commissioner to decide, right? That is really your opportunity to use these standards to say, hey, let's be honest, you wouldn't say this at the meeting, but someone bringing in a vacuum cleaner is not a scientific representation of the impact that that car wash is really going to have. And I'm someone who grew up next door to a car wash, so I am intimately familiar with what that sounds like. And so that's probably not accurate, right? What I will say if I'm hearing this case is I'm asking my staff, hey staff, has there been a sound study done? Not all cases are going to require a sound study, but sometimes they might. Your code, and you are not expected to have your entire code memorized, but your code will have regulations in there that are about the specifics of sound, light standards, smells sometimes, explosive materials. Codes get very, very specific about how these businesses are allowed to operate. And so it is a reasonable question if a homeowner were to bring in a vacuum cleaner and make an accusation that this is what it's going to sound like. Ask your staff, what are our code's regulations as it relates to sound? Someone had mentioned in the chat, this is a great opportunity, and we don't have the time to get into the specifics of this tonight. But this might be where you bring in your conditions, where if you, after hearing all of the evidence, and the public testimony is one piece of that evidence, it might be a reasonable condition to talk about mitigation of that sound. Maybe the applicant is required to install a sound wall if they abut residential property. I've done that before as a staff member. Maybe there are some limitations on hours of operation. Maybe, and I promise you, your staff will have already worked with them on orientation and all of that kind of stuff to mitigate that impact as much as possible. But and Adam in the chat kind of alludes to this, if you feel very swayed that this is going to be enough of an issue, you should vote no based on standard C has not been met. And you should be very clear in saying that when you're having that discussion. You should be very clear in that. If you do feel that you're voting yes, I think it's also reasonable to say I'm voting yes because I feel the standards have been met. If you feel that only some of the standards have been met and not all of them, it's totally reasonable and good practice to say I am voting to recommend approval of this because I feel that standards A, B, C, and D have been met so strongly that that is enough to sway me to vote yes. It's very, very good practice to make reference to the standards when you're having your discussion.
Yeah, and I just want to jump in there because we had questions during our planning session when we met with the professional staff to talk about, well, if the findings were not found, that sounds kind of silly. If the standards were not established, we cannot vote to approve it. And let me just say again, your zoning code has all of the zoning codes have different languages on that. So some of them say, you know, this following standards shall be met to approve. You know, we can get into statutory interpretation, shall versus may versus must. That's not really necessary. What we will say is that when it comes down to the brick and mortar, when the rubber hits the road during litigation, what the court does is they don't take the list of standards or the LaSalle factors. I was impressed by our participant who referenced the LaSalle factors. They don't
10
take it
points.
and go through with a red pen and check off the LaSalle factors. It's a balancing test. So they say, on the whole, is this a rational decision? The LaSalle factors are kind of the way that guides the court's analysis. So as a best practice, we do like to see a full mirror image between the findings and the recommendation. If you found all the standards are met, you're voting to approve or recommend approval. If you found that one or more of the standards haven't been met, maybe the commission votes that they're not going to approve it no matter how strongly they feel about A through D, and E and F are off the list. However, that's just a best practice. When it comes down to the real risk, you should talk to your attorney about what happens when when we vote this way. And usually the answer is the risk is relatively low. And again, that depends on your community, but it's a good thing to think about.
I've met some staff attorneys who like it when every single time the findings of fact has some standards that are met and some that aren't, because they like being able to justify in either direction as to which way the commission has voted. So it really is a conversation with your own staff and what they prefer. But I think my advice to every planning commission I meet is, as long as you're making a clear link between the standards and your recommendation, as long as there's a link and that link is clear, you are doing your job of being a recommending body who makes recommendations based on standards. That is the most important thing to me as a professional planner. Cool. We'll do another one. Mixed use multifamily development. I know Dan Lau was in the chat, so now I'm nervous. No one knows multifamily development better than Dan Lauber. But a developer has plans to build a mixed use multifamily development next to a train stop in a municipality. An objector provides some testimony that this development should not be recommended because it will bring traffic to the area. A traffic study was completed, and while traffic will be added, your professional opinion is that the amount of traffic is not egregious. How do you respond? And this could mean, how do you respond to the objector? This could also mean, how do you respond to the standards? I'll give you guys a minute to pop some thoughts in the chat. You'll note that it's next to a train stop, so Adam, that's how you notice it's not a Hoffman Estates case.
So does anyone have any thoughts? I'm not seeing a ton. So I think what's interesting is that I think this is one of those cases where we're, again, and I know it's like a broken record, talking with staff is going to be really important for this, because the traffic study, and I'm not an engineer, I'm not a civil engineer, I'm not a planner, certainly, but understanding, what the traffic study means and the confidence in its results from professional staff can be really helpful, I think, in evaluating, if it's next to a train station, how does that impact traffic? What are what's the use, how many people are using the train versus driving? And what's the parking situation for the multifamily development? Those are all fair questions to ask. And I hate to pass the buck to Phil on this, making staff answer those questions, but that's what they're there for. And I think when we're talking about these studies and evaluating these complicated documents, they can be a huge help.
Yes. I see someone who said, ask the objector to list pros and cons and debate it. No. Please don't do that. This is where your people management skills come into practice, right? This is where the soft skills of running a meeting are so important, because your answer, especially my chair people in the chat, your answer to any time someone comes up and makes public testimony, thank you for your public comment. And that's it. We really don't want to be getting into an exchange. I know sometimes in a public hearing there is that need to be open and available for cross-examination, but the worst position you want to be in is if you're getting drawn into a debate with an applicant or a member of the public, or I've even seen your own staff. Your staff are on your side. You both are there to represent the village or the city or the town. Um, Traffic studies are a difficult one. I am a transportation planner. Um, Traffic studies trip people up a lot of the time because everybody hates traffic, and traffic is a very emotive issue, right? If there's one thing every single person can agree on, it's that they hate traffic. And so this is again why those soft skills and that meeting management is so important, because that person who's bringing this objection needs to feel heard, right? So you need to thank them for their comment, and you need to show that you understand that they have concerns about traffic. But the fact of the matter is, traffic exists often whether or not a development is going to happen. We have a lot of data that shows us the no build versus build scenarios through the year 2050. So we know these numbers. A lot of the times, especially when it comes to multifamily development, there's a lot of fear about the traffic numbers, but the science shows us that multifamily developments typically generate less traffic than the equivalent single-family developments. This is all provable data, and so often when people bring objections, your job as a commissioner is to weigh the um, relevance of that testimony, right? And so it's not to just take everything on its face value. And it's to hear that person out and say, hey, we understand there's concerns about traffic. Based on the standards for this, I think it meets the standards and will recommend approval. If you think it meets the standards and it recommends approval. Someone in the chat has mentioned there's a level of service rating that different roads get. And yeah, absolutely have that conversation with your staff. If your staff is good, which I'm going to assume they are because every planner is fantastic at what they do, no exceptions. If it's going from a level of service A to a level of service F because of this development, something's gone really wrong and we probably need to be figuring that out, right? But again, my biggest message to plan commissioners is you should never feel pressured to be doing all of this on the dais, right? Trust that your staff will have put work in ahead of time to get the project in its best situation to be presented to you, right? The term I like to use is substantial compliance, right? When I was the type of planner that brought cases to a planning and zoning commission, my job was to get it as close as I could to perfect for them to see. So that is the I guess that's my 2 cents on that.
Yeah, and I just want to say, Phil, I really liked what you said about like what using your judgment and evaluating and weighing and deciding what's relevant. We saw some questions earlier on the special use when we were going through the standards and on the special use example about, what does adequate mean? What is reasonable? And as an attorney, I can say that going through school and talking with people, and my mom watches a lot of good court TV. She's always like, oh, those standards, what's reasonable? Reasonable doubt, what does it mean? And really at the end of the day, when it comes to these standards, your role is to be an evaluator. It is to exercise judgment. And think about what the alternative would be if every term, every word used in the zoning code were defined, if adequate was defined, if, we talked about some other issues about like, well, what does this mean? If every term was defined, there may not be a role for the plan commission anymore because you wouldn't need to exercise judgment. You could go through the definitions, decide that yes, by more than 50%, it's adequate. And that kind of takes away the local control over zoning that we so enjoy in Illinois. It's such a tradition that communities have a lot of leeway to decide what's best for their community in terms of land use and development. So just want to stress that it can be frustrating to grapple with these very amorphous words like reasonable, what's adequate, but embrace that flexibility because it helps you, use your judgment during these hearings and hopefully have a really good debate and assessment of the factors.
Use your plans as well, right? So imagine this exact scenario, but your community has just gone through a comprehensive planning process and discovered that you have a huge need for housing, right? That is something that should factor into your decision making when you're considering cases involving new housing, right? Our community has a need for housing, and one of your standards will be, does this proposal meet the planning efforts of a community, or some words to that effect, right? So if your community has a need for housing, that might play a part when you are considering it against the impact. It doesn't mean that there is no impact, but the calculation in your head should be, do the benefits of this project outweigh the potential impacts? Because remember, more often than not, the people who come to these meetings are going to be the people who have an issue with that development. They have some fear, founded or unfounded. The people who are in favor of this, who might benefit from that new housing, who might get the job in the warehouse development being proposed, they're probably not coming to your meeting. So when you make your recommendation, you're making a recommendation for the community as a whole, and not just that hyper-local group of people who, yes, they may feel some of the negative impacts more so than their neighbors, but you also have to take into consideration the benefits that it might bring to your community as a whole. We'll do one more of these because I think it's a really important one, and then we'll hit some questions because we're about at time. So PUDs, planned unit developments, whatever you call them in your community. For those of you who need that little bit of a refresher, this is a typically large-scale development, and it's usually when a developer needs a significant amount of relief from your code. And in exchange for that, there's a mechanism built into these to where they can get that relief or those variations, whatever it might be, in exchange for a development that provides some public benefits. And usually that's open space or certain amenities. Maybe they'll make a donation. It could be any number of things, right? Open space is the traditional kind of heart of the traditional plan development. So developers requesting approval of this plan development for a mixed use. So that means they're going to have residential and commercial, retail. Your code requires the Plan Commission balances the public benefits associated with the project, and there are numerous objections raised at the public hearing. So the question to you is, what is a good balance? I guess we can just dive into that while people are chatting. Is this the example when a property is sat vacant for a long time? Let's say yes. Let's say this is a property that, a lot of our communities now are very built out, right? We're very landlocked. So you'll see a lot of significant redevelopment of sites that haven't been used for a long time. A lot of office buildings will be like this now because the world of office has changed so significantly recently. Or it might be, a very difficult to develop piece of land. Maybe it has grading challenges. Maybe the cost of filling that land would be prohibitive. And so that's where you'll see a lot of the times a lot of planning commissioners talk to us and they're like, well, why do all these commercial developments and these big developers want a lot of variances, but I'm not supposed to grant them to my neighbor who wants a bigger fence? The statistics just kind of bear out that the likelihood of a big development needing a variance because the land is a challenge is going to get higher over time because all the good land has already been developed, and what we're left with is the land that is going to present those challenges, right? Your neighbor needing a big fence is likely not based on the land. Erin.
Yeah, I was just going to respond. I really like the comment that Dan left in the chat. So it really depends. And again, what a literally response. It depends, and that's true in this case. So when we're talking about public benefits, I think there's some case law of the Supreme Court that says, maybe you've dealt with developments where there's a park donation because that's part of the village code or the city code that for all this space, you need to develop a park or donate land for a park or donate money for a park. And that's pretty common. And so if the objections raised are from neighbors, and if one of the standards, let's assume, is it shouldn't have an injurious effect on your neighbors, which is a common standard across most of these codes. And someone comes in and says, this is going to be way too loud. I'm really concerned about noise and traffic. Noise and traffic are those two things. And the public benefit one of the public benefits that's being offered is open space or a park space, those kind of amenities that might be associated with a development like this. It's up to you guys to determine really, are these fair? First of all, are these concerns about noise and traffic fair? Has a sound study been conducted? Has a traffic study been conducted? Have I talked with staff about those things? Is there anything that we can do to evaluate that more closely? And then, as suggested, is there a rational linkage, like a nexus between what the amenity being offered and some of the issues that are being raised by the objections, or issues that have been noted by staff even in reviewing the application, if we flip it back the other way. So thinking about, would a park do anything to combat traffic and noise? I don't really know. Maybe more people would ride their bike. It's a little speculative for me to be, just talking about it here. But thinking about the rational relationship between the benefits being offered, the amenities being offered, and some of the major key concerns with a big development like this could be helpful for just, making sure thoughts are along the same lines.
Yeah, I mean, we're intentionally vague with how we wrote this because there's so many different permutations of this that you could see. Something that I really want to touch on is I think a lot of the times you'll hear objections saying, there's a lot of fear of developers as outsiders coming in to make money. And that leads to, we hear that a lot from members of the public and objectors that, well, they're just trying to make money. Yes. The United States is a capitalist society. I'm not originally from here. That's something I had to memorize for my citizenship test. That is what it is, right? So the real question is, okay, yes, we know that the developer is here to make money, but are they making some money by offering a product that the village or the municipality desires? And how do we know what the municipality desires? We look back to our comprehensive plan, our sub-area plans, our planning documents, and that connection that zoning is a tool to enact the plans of the village, right? And always remember that your elected officials are going to have a bigger purview than you. They're going to be considering financial impacts, tax-based impacts, things of that nature. So sometimes their vote is going to differ from yours, and that's because they have more things to consider than you do, not least of which, let's talk about the elephant in the room. Will this help me get elected next time around? That is something they have to consider. That is not something you all have to consider all the time. So we'll wrap up. We'll skip the last couple of these because I think that was a good one to end it on. I want to touch on takeaways real quick, and then we'll have some Q&A. So if you remember anything from this session at all, just remember to use your standards, whatever they might be. Work with your staff on them. They help you if we ever end up with some litigation. They are a great communication tool between you, applicants, members of the public, staff. They're a common language that we can all share. They help your elected officials because your findings of fact, that document gets transmitted to them. So instead of them having to read through all of the minutes to find out exactly what happened in a hearing, instead of them having to relitigate things that you've already discussed, they have a one sheet, very simple thing that really supports them in making an important decision for your community. And it also helps define the role of your planning commission. A lot of the times when we're called out to training, it's because there's a disconnect between, well, I thought I was joining a planning commission to do X, but really I'm doing Y. And if we're constantly using those standards and having a clearly defined role, that goes a long way in helping a lot of comfort during these meetings. Erin, do you have anything else on takeaways?
No, I really like that. And I think, when it comes to your role, it's a very important one. And I think, I don't work in a community, I'm not in in-house counsel anywhere, but I always appreciate that, for folks who volunteer their time, take their time to do this really important job, it's a difficult job. And I think Phil mentioned that at one point. It is very challenging. And, I have the benefit of, going through this on the back end sometimes in litigation where I have the benefit of reading the minutes, reviewing the applications in depth, doing that kind of hard work, with the benefit of hindsight. And you guys, it's a challenging job. So I think really see the standards and the findings as your friend rather than as Phil mentioned at the top, constraints that make your job harder. At the end of the day, your job is hard enough, and the findings and standards are there to help you kind of take the pressure off of the analytical piece and remember that the findings are kind of your fallback. If there's a really hotly contested public hearing, if there are things you're not sure about in the application, go turn to the findings, talk to staff, and hopefully you guys will be on your way to making, a good rational decision that ultimately, the village board or city council is going to do with what they want. So, it's a good, I'm glad you all were here today.
Tom, you want to run us through some of the hot button questions? I know we're quite at time, but if we have questions, I'm happy to stick around for a little while and answer some.
Yeah, I can go through a couple. One question was, given that due process requires that an applicant is entitled to a zoning decision based on findings of fact, shouldn't a zoning board determine and adopt findings of fact before it votes to approve or deny a zoning application? In my community, the ZBA continues to vote to deny or approve first, and then instruct staff to draft findings of fact. Is that the right flow, so to speak?
Interesting. Okay, well, I'll give my 2 cents on this. And again, our thoughts here are kind of best practices and general advice. So always talk to your attorney if you've got huge concerns about this. I would say that a best practice is to adopt the findings first and then vote to recommend approval or denial. That's because, as Phil said, the link between those two things is pretty tight. You want to be able to rationally link, and I think Adam earlier said in the chat, isn't it good when we're voting on the approval or denial to reference the findings? Absolutely, I think it is, because at the end of the day, when we're thinking about whether it's a rational decision, the findings are standards for, decisively showing that it was rational. And I think voting to approve the findings and then voting to approve, a recommendation of recommending approval is just a really good practice so that everyone's in lockstep with one another about the findings, what we decided, how those are related.
Yeah, one practice that I kind of like, and I know sometimes it causes some consternation for a developer and sometimes for a commissioner too, but I always like having, when we say a draft findings of fact, I mean, your standards are your standards are your standards, and they're in the code, right? Unless a text amendment gets passed, they don't change. They're codified. If you aren't sure whether something meets or if it's a particularly contentious case, and I've done this, right? You can continue a case, right? So that staff can go away, draft findings for you if you're a community where staff drafts the findings. Staff can go away, draft or redraft the findings based on something that happened during that hearing, right? And then they can bring them back to you in a second meeting. That's something that's an option that you always have. And I know a lot of staff attorneys prefer that because they like the fact that the commission is voting based on a set of findings that they've all seen. Similarly, if the findings have been drafted to staff's ability based on what they know from the technical review of all the plans, but then something happens completely out of left field at a meeting, which happens, that's not necessarily just public testimony. Maybe the applicant is like, oh, well, I'm here applying for 10 units, but what if I just did 6 instead? And that completely changes everything. Continue that meeting, right? Continue that meeting, because you are never, ever expected to be in a position to be litigating this in real time. That is, you always have that option to continue that meeting. If it's a very minor thing and there's just one commissioner who is like, I kind of don't agree with this, you as that commissioner have the right and the ability to propose a change in the draft findings, have that discussion amongst the commission, maybe take a straw poll. If there's consensus, you can make that amendment. You have the ability to amend the draft findings as a commission. If there isn't consensus and one commission is just out on their own with a different opinion, that commissioner can vote no, while everyone else votes yes. And that's how it works. It's beautiful. We can have differences of opinion. It's a beautiful thing.
Okay,
That was
maybe,
inspiring, Phil.
maybe one last question, I don't know, before we wrap up.
Yeah.
Should applicants applying for a special use, a variation, or another type of request be responding to the findings of fact within their applications? And if so, how should a planning commission gauge such responses if the applicant does not put a lot of effort into those responses? So it's maybe like what Phil was talking about earlier in the presentation, where if it's a resident and maybe they're not as familiar with zoning codes or quite, they don't quite understand how they're supposed to answer questions if they're filling out an application for, does your request meet standards? So how would that work, would you say?
I think the first thing to note is that if you're seeing the application for the first time in the couple days leading up to the hearing, because you're reviewing the packet ahead of time, and just know that staff has reviewed that application many times, probably by the time you get to a hearing, and they know it. If not, if they haven't memorized it, they know it very well. And so usually what we'll see is if the applicant submits findings that are yes, no, yes, yes, or they're going to say yes to everything, right? They're going to say yes. And there's no detail provided whatsoever. Staff can go back to them during the submission phase and say, hey, we need a little bit more than that. How are you showing that this isn't injurious to your neighboring properties? Or for the variation, that's a great example. Show me what condition on your property is making the setback too onerous for you to comply with. What's going on here? And usually that process is done before we ever get to a hearing. And that's where the applicant submitted findings actually are really useful, because it opens a dialogue with staff, and then in turn opens a dialogue between the commission and the staff to say, hey, we saw what the applicant submitted. It seems a little different than what staff is saying about the setback. Can you clarify what's going on there? And really, that's what we're doing. And I
That's
see
healthy.
someone said, they should have done their homework prior to submitting. Sometimes folks just don't, if they're not always the most sophisticated actors, for lack of a better phrase, and sometimes it helps a little to get them going there if ultimately the relief is what they're seeking.
I used to be a teacher before I was a planner, and just because everybody's done their homework doesn't mean they've all done it well. I can tell you that from experience. I think the other thing, something that I want to stress, and this is a best practice recommendation. This is general. A lot of commissioners ask us a lot of the times, what goes into a findings of fact? What constitutes a fact, right? And maybe there's an expectation that there's like an essay written for each of the standards. My opinion as a best practice is that the shorter the answer is to each standard, the better. The more concise it is, the better. So sometimes, yes, this will not be injurious to the use of the property, is acceptable as a written response to the standard and the finding. Where that detail will come is in the staff report, in the presentation by staff and by the applicant, and in your own reading of the plan and discussion with the applicant. So just because there isn't an essay that details it's impossible to be completely comprehensive of every possible fact, because how far back do you go? If we're saying like, yes, there is a fence, do we then go back to define fence? Do we go, how far back do we go? I much prefer finding a fact that is clear and concise, that yes, it meets the standard. You don't need to evidence that in the written response to the findings. It's good to be concise, and the evidence comes in all of those other data points you're going to have.
Can you address the question about the design qualifications when every other aspect of the proposal is appropriate?
Sure. Tom, your voice sounds so different. Cool. I'm looking at this now. What about when a PUD satisfies most requirements in size and form, but does not meet design and material guidelines established for the neighborhood? This would be seen as an aesthetic issue, yet neighborhood has design standards. I can't speak to the specifics of your code. I can speak to experience I have with working with design standards, right? And I think it's in the same vein as to other things we've discussed this evening, in that it feels like a cop-out answer, but it's not. The answer is it depends. The question that is a fair and reasonable question for you as a commissioner to ask: why? Why can you not meet the design and material guidelines that are laid out in our code? Firstly, you need to know that they're in your code, because that's a very different question, right? If they are in your code, then it's a fair and reasonable question to ask the developer, why can you not meet these standards? It is then your value judgment as to whether or not that is a reasonable response. And you have the right to either recommend approval, because after hearing it, you're like, okay, it is reasonable that they need a waiver from these design guidelines based on the information I've collected. Or you also have the right to enforce your code and not recommend approval because they cannot meet those design guidelines. You are under no obligation to allow someone a variation from your own standards. Erin, do you have any legal thoughts on white stucco versus brick?
I can say that we've had litigation over roof tiles. So, you know, to the extent that I think Phil's advice is really well taken, you know, if they're along the same lines of what we're talking about, it's a role for all of you to evaluate the standards. I feel like a broken record saying the standards, and then determining whether or not there are sufficient justifications to approve in spite of non-conformity with those design standards. I actually don't see a lot of design review. I think a lot of the communities where we work with delegate that to the zoning administrator or a different body. But if it is something that's in your purview, definitely consider it in the way that Phil suggested. I think that's great advice.
Thanks.
All right.
Any more questions you want to give us, Tom? I see one about morals that I'm happy to jump in on.
You go ahead then, yeah.
I'm often hung up on the word morals in our community's findings of fact because of its inherent subjectivity in what is already a very subjective process, particularly at community level. How do we clearly define what is moral or not for everyone? Morals is kind of pulled from some of the, ancient case law that really finds and started the police power for communities to enforce their own zoning laws, right? So it is very much of an era that, in this humble planner's opinion, is way past, right? And so there's two ways to look at that. I think there's a way in this question, which I agree, it is very subjective, and there's a negativity to that because at times it can feel opaque. My advice as a general best practice advice is there are probably other standards that you can base your decision on that are going to be much easier for you to defend, not necessarily legally, but just in terms of human to human conversation. It's going to be much easier to say it doesn't meet this standard of injurious to other use, as opposed to it doesn't meet my moral standards, right?
Yeah, and I just want to say that like Phil said,
That's going to be a very difficult conversation.
That's a weird vestige of the original, zoning cases, the Euclid case, and some of the other cases that are kind of planners and lawyers know well if you do any land use work. And really what it's public health, safety, morals, and welfare are kind of, and that message is burned into my brain. It's I've got a tattoo. No, I'm just kidding. But those are the phrases that we all know very well: health, safety, morals, and welfare. And really what the findings are is a more usually a distilled version of what a community has decided are the factors that go into those kind of difficult questions, like what are the community morals and safety and welfare. And so you can usually turn to your other standards, like Phil said, to say, I think that, if we can't all define morals, which I certainly can't, those other standards kind of help you have those conversations about, is it consistent with our plan? Is it consistent with the pattern of development in our community? And it's mostly just a very old way of thinking about things. It's a vestige of former case law.
And if that's actually in your standards specifically, it's worth having the conversation about updating your code, because what you'll see now is that the zoning code itself will be prefaced with the intent of this zoning code is to uphold the public health, moral safety, and welfare of the village of blank. But then the standards, like Erin said, are a much cleaner, more broken down version of that. So if you're finding that in your standards themselves, it might be worth getting some plainer language standards, like the ones we gave. Cool. Thank you all so much. Tom, do you want to give a final plug before we end the evening?
Sure. No, I was going to say this was great. So thank you for all the questions and commentary. We really appreciate it. And if you enjoyed this session and maybe your community hasn't had the opportunity recently or at all to have an actual plan commissioner or zoning board training session, then reach out to me at podo at ilapa.org, and we could set something up with your community. We'd love to do that.
Yeah, and if you do have any more questions, feel free to email them over to probably Tom.
Sure.
And he can, I can't guarantee that Erin will be able to answer all of them, but I'll definitely take a stab at some of them.
Yeah, we'll do some good, nice thinking on them. And thank you all for your thoughtful questions. You definitely made this a very interesting session. It's always hard to present to a cold room, so definitely wasn't the case. And I'm so glad we were able to present to you tonight.
And for those of you interested, the latest episode of season 2 of Severance has just gone live on Apple TV, so that's what I'm going to go and do now.
Have a good night, everyone.
Thanks very much. Thank you.
Thank you.